morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime Live. This is where we cover some of the most interesting live trials in the country today. And today, I'm so excited. We are covering a major trial, the Tex McIver case out of Atlanta. It is slowly concluding. It is slowly moving ahead. And I'm going to tell you that the defense will probably rest tomorrow. This case has been so exciting. And yesterday, there was a bombshell in the courtroom. Now, again, this is that case of that prominent attorney, Tex McIver, who's on trial for shooting and killing Diane McIver, shot her from the backseat of a moving car. But he is claiming that this was all a tragic accident. He is denying the prosecution's idea that this had something to do with financial gain. He said this had nothing to do with that. We're going to explore that a little bit later. But Mr. McIver, okay, was not only charged with murder, he was also charged with 3 counts of influencing witnesses. That's right. The prosecution felt that he did something to try to cover up what he did. Now, we learned yesterday the judge dismissed 2 of those influencing witness charges. We are going to talk about that in a little bit. But before we get to the live feed in the Tex McIver courtroom, and again, I'm looking at the feed right now. I'm waiting for the courtroom to start. I'm waiting for trial to start. As soon as it is, we will make sure to go to it. But before we do, I have to preview a major case that we'll be covering starting tomorrow. And this is a fun case, okay? This is the case of David Copperfield. That's right, the magician from Las Vegas. While he and the MGM Grand are being sued by a man named Gavin Cox. Gavin Cox was an audience member during one of David Copperfield's shows, and he got injured during a trick. Now he's suing. Now, unfortunately for Mr. Cox, I know he suffered some severe injuries, and that's very unfortunate. But on the lighter side of this case, we may learn some of David Copperfield's magic tricks. That's right. So we have a short preview about this case that will be starting tomorrow. Take a look.
World-famous illusionist David Copperfield might be forced to break the cardinal rule of magic and reveal the secrets of his illusions in open court. Copperfield is being sued in Las Vegas civil court by 57-year-old Gavin Cox, who claims he was injured during a 2013 Copperfield show in Las Vegas. The British tourist who once cooked for British royalty claims he fell and struck his head on the ground after tripping over construction debris as one of Copperfield's assistants whisked him and other audience members through a dark, secret passageway during the disappearing stunt. Cox claims he suffered brain trauma and is forced to wear an oxygen lung at night because he stops breathing when he's asleep. He's seeking punitive damages from Copperfield and MGM for alleged negligence. The illusionist and hotel strongly deny all claims, stating Cox's injuries were pre-existing and or unrelated medical conditions. This is Aaron Keller for the Law and Crime Network.
This is going to be a good one. All right, this is going to be a good one. But before we saw anybody in half, let's get back to the Tex McIver case. That's our main focus for today. And right now, I want to bring in my very special guest, Law and Crime trial analyst Bob Bianchi. Bob, it's good to see you.
Great to be with you again, Jesse.
Okay, let's talk about Tex McIver. So 2 of the 3 influencing witness charges were dropped. The defense made a motion to try to have them dropped. The judge agreed. What does that mean, and where are we right now in the case?
It's, once again, in my opinion, with all due respect, and I'm a prosecutor by definition, a homicide prosecutor for half of a career, it's amateur hour. This case, you never bring a charge to a jury and open up and put evidence on to have a judge later dismiss it. You lose credibility in front of the jury, and you create a whole constellation of legal issues on appeal. For example, the one charge that he had tried to influence law enforcement improperly, tampering because he asked his PR person to put a spin on a story, was something that was never able to be survived. And Jesse, as a trial lawyer myself, when I have gotten in and before I went to a jury, all good prosecutors do this. They look at their indictment, they look at their evidence in a final analysis, and I have, in some instances, just dismissed certain charges before we went to the jury to avoid exactly what is happening here, substantial blow to the prosecution.
So this is rare. In other words, it's rare that we see motions being made for directed verdicts to dismiss counts. This is rare that a judge would actually do this. And what you said is one of the charges was that Tex McIver was trying to influence Bill Crane, who was his PR specialist, to put a spin on that Black Lives Matter comment. Mm-hmm. And then they also, and I have to say, I'm more surprised by this one, the charge about Tom Carter, who is Danny Joe Carter's husband. And remember, Danny Joe Carter was the driver of this vehicle where Diane was shot. Tex called, left a voicemail, said Danny Jo's going to get me a lot of trouble. She's going to send me to prison. Almost trying to see to delete this message. That seemed like he was trying to delete evidence in this case. Why was that one dropped?
Yeah, well, tampering with an investigation requires a lot of proof of a very specific intent to purposefully derail an investigation, as opposed to telling people to lie about it to get yourself out of trouble. Many times in cases I've handled in an entire career, people are trying to spin it to their family, for their friends. They don't want to look bad. They think that somehow this is going to make them look bad in the court of public opinion. So these are not unusual things, and to have criminalized them via an indictment that later gets dismissed is outrageous. I'll tell you, in all the years I've prosecuted cases, I have never had ever at the end of a case a charge dismissed, which essentially meant the judge found there can be no inference, no possible way a reasonable jury could find you guilty of this charge based upon the evidence that you, the prosecutor, presented in this case. I've never had it happen to me, and it shouldn't happen. It's amateur hour.
Okay, so let's try to take where we're at right now. So that means that Mr. McIver is on trial for murder and then one count of influencing a witness, and he also faces other charges. I'll read them correctly. He's murder, felony murder, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, and then one count now of influencing a witness. That witness is Danny Jo Carter by telling her at the hospital, listen, don't tell the police that you were there, don't say you were the driver, don't say you were involved in this, but he did it for, you know, her own good. So if, again, we had the conversation at the beginning, if he is not found guilty of murder, that leaves the other charges, but it's possible he could be also left, if they do a lesser included, with involuntary manslaughter. In other words, break it down for our audience right now. What could he be looking at the minimum, and what could he be looking at the maximum?
Okay, so that's a very good question.
Bob, I'm sorry to interrupt. I think we have a live feed in the courtroom right now, so I want you to stand by. We'll analyze what's happening, but yes, we do have a live feed right now in the Claude Tex McIver case. I don't want you to miss anything. Stanley Smith, who is an estate lawyer who helped advise Tex McIver about selling Diane McIver's jewelry and fur clothing, is on the stand right now. Let's listen in. All right, everybody, you're watching Stanley Smith, an estate lawyer who was representing the estate of Diane McIver after she died. Now, I'm here again with Bob Bianchi, our law and crime trial analyst for this morning. You hear what the prosecution's really trying to get out of him, but they're not getting the answers that they want. Can you break it down for our viewers?
I'm sorry, Jesse. I fell asleep in the middle of the testimony, or at least I blanked out a little bit. Dude, if this was my assistant prosecutor, I'd be dragging him into my office and saying, what are you doing here? First of all, the guy's giving great answers for the defense in terms of the loving relationship, and you never ask a question you don't know an answer to. Although they say that's an absolute rule, it's a pretty good rule. You sometimes want to let it out a little bit, see if you can fish and see if you can grab something good. I don't think he's doing any damage to this guy. I think the jury is oh-hum about this money. Either they're going to believe that that gun was accidentally fired or not, and the central part of this case fell apart when the state's ballistic expert misfired the gun himself while sitting in the witness chair. The jury's tired of this, in my humble opinion.
Yeah, and especially since he's not getting really the points that he wants to get across about the fact that, all right, you told him to sell the furs, but ultimately it was his decision. Well, he's like, he should have sold the jewelry, and he should have sold the furs. It was important to him to get that cash, and that point is he keeps trying to make it, and it's not really working for him.
Here's what you do in cross-examining this witness tactically. You can, through cross-examination, bring the theory of your case back out again with the witness by just yes or no questions. Is it not true that she had this estate? Is it not true that she had this much money in the estate? Is it not, in fact, correct that after she died, he got that money? Is it not true? You just do it short, sweet, to answers he has to say yes to, and in essence, you're just reintroducing your financial motive to the case. But to be asking these open-ended questions and having this guy basically, in my opinion, spank him a couple of times with them, with no cognizable theory of the case coming through other than the same old thing, I think is, again, I'm sorry to say it, amateur hour.
All right, everybody, let's listen back in, and maybe this amateur hour will not continue anymore. Let's listen. That's Stanley Smith, an estate lawyer testifying there in the Tex McIver case. I want to talk to Bob Bianchi right now. Bob, again, we're talking about this witness, trying to understand what Tex McIver's activities were out when Diane McIver died. So in other words, do you hear the prosecution saying, well, maybe you shouldn't have followed a legal advice here and kept on to those sentimental items, and you shouldn't have paid out this and that, and basically questioning the value that Tex McIver had in Diane McIver's estate? Do you see anything suspicious here, or do you see something that a spouse dies and this is the normal operation, this is the normal procedure of how things go?
I mean, it could be either way. The point is I don't think they're scoring points with the cross-examination of this witness. Again, Jesse, what they should be doing is highlighting the motive of their case, which is a financial motive, through this witness with yes or no questions, and get out of that cross-examination. Sometimes it would be even better not to cross-examine because all of that information is there. And so, in fact, you could say at the end of it, this is what I would be doing, is you have this money, he converted very quickly, there was a lot at stake, and boy, that's one heck of a motive to kill somebody, isn't it? Objection. Oh, sorry, I withdraw the question, Judge, and sit down. I'm not seeing this doing anything. I'm sorry.
Yeah, you know, the idea that they keep trying to press, well, if this, okay? So in other words, if before Diane died that she had the ability to foreclose on the ranch, she could have had it vested in her, put it in her will, and sold it. But again, that's not what happened. So what is the prosecution trying to say, that Tex McIver manipulated the conversation about the wills beforehand? Have they been trying to show that there was this mysterious second will for Diane McIver that he somehow got rid of? How much is the jury taking from this? And you know, when you bring in numbers and you bring in all these calculations, and we had a financial expert, we have an estate lawyer, things get complicated. People wanted ABC. Break it down easily for me. So how much are they really making of the financial motive here?
It's the only thing that they have, and from the beginning of this case, we have been discussing, Jesse. The idea that financial motive only makes sense in a homicide prosecution if you can show and establish through other outside independent evidence that he was agitated, he was angry, he was mad, he was overwhelmed. Because what the defense, I'm certain, is going to do in summation is to say, all sorts of marriages have assets in them, and people that are high-end have different accounts and things of this nature. It is not a sufficient enough motive to necessarily kill a person, especially when the state has one big hole in its case. Everyone that's getting up there, even from the prosecution side, is saying they had a loving relationship, that this was not something that was overwhelming to them, or that he was upset about this. This is just people that, in other words, you're going to penalize him because they had money, and like every other couple that has money like this, they have lawyers and people that decide what the wills are going to be or not be. If the state is resting its case solely on this motive, the fact that people have money, and without anything else to corroborate that he was angry, agitated, and that he decides to get into a vehicle, and this cockamamie thing that the gun is in the console, and then he has her bring the gun back, and then he fires one round, and if he missed, then she'd still be alive. That this cockamamie thing was all created because of a financial motive. I think they're losing the case, the defense of the prosecution.
Well, let's see how the defense is doing when they go back with their witness, Stanley Smith. Let's listen in. All right, everybody, an important witness on the stand for the defense, but that's not the only important witness that they brought out so far as they have the case. We saw yesterday the testimony of Dr. David Rye, a sleep expert, for lack of a better term, and he basically testified to, did Tex McIver suffer from a sleep disorder on the night of the shooting? Well, let's break it down here with Bob Bianchi. Bob, what did we learn from the sleep expert from yesterday?
Well, the sleep expert was opining that he has this sleep condition, which is consistent with what the defense has been saying, and they did it through this expert witness. And so that your viewers understand, expert witnesses are people who have a specialized knowledge and that the court says can actually offer an opinion, as opposed to every other witness, which is a fact witness that cannot offer opinions. Now, I had said yesterday when I was on the show that if this expert is the only person that the defense is putting on, and that there's no pre-existing condition to support that expert's conclusions, it could be seen by the jury as a guy who just kind of came in, he's getting paid, and he's just going through the motions in order to help the defense. But, in fact, we learned through that expert that he, in fact, had this documented history for a significant period of time before that. So that supports and buttresses his testimony, which therefore supports and buttresses the defense's argument that he may have had this condition when he was sleeping inside the vehicle.
Seems the defense is doing a good job so far of poking holes in the prosecution's case, including with this witness, Stanley Smith, who's on the stand right now. Let's listen in live. All right, everybody, there is a jury question going forward. By the way, I'm here with Bob Bianchi. Bob, what do you think of Judge McBurney's style? He has been criticized online for providing the prosecution not only with leeway, but when there is an objection, he gives them sort of an alternative question that they could ask. I haven't seen so much of that happening in courts, but what do you think about his style?
Listen, I think he's doing okay. It is offensive to me as when I have an adversary, whether I'm a criminal defense attorney or a prosecutor, and the guy does not know how to ask, or the person doesn't know how to ask the question the right way, and the judge suggests how to ask the question. But I have seen that done often by the judges. I think it's really more of a frustration. The judge knows what the lawyer's trying to get to and basically says, here's how you do it. But, you know, it's funny that you're asking this question because lawyers should know how to ask admissible questions. And some of these questions were so wildly speculative on cross-examination.
Don't they want to try to get something, sneak it through, if I can get a little bit more information or flavor my question a little bit more?
Well, this is what we call looping. It's a principle where you are giving a big set of facts and then saying, isn't that true? Or is that accurate, or is it not accurate? But when you're asking people to speculate about the state of mind of other people, any lawyer is going to know that that is going to be an objectionable question. The judge knows where the lawyer is trying to go, so he suggests a question. I prefer judges not to do that. Let the lawyers try their case. If they can't figure out how to ask the question the right way, then so be it, because it looks as if to the jury, which is most important, because in the end, it's all about the jurors. It's not how smart you are. It's not that you went to law school. It's about facts and what the jury thinks about them, and it kind of makes it look like the judge is actually favoring one side as opposed to the other, which is something I don't like.
Speaking of the jury, we're waiting for a jury question. What do you think about when a jury is allowed to ask questions of the witness? Does it give you an insight into how they're thinking about the case? Oh, my God.
I had one of the first cases in New Jersey where they allowed this, and it was actually in a civil case. And it was funny, Jesse. You go in the chambers, and the judge in that case would review the questions with the lawyers. And, yes, it definitely lets you know where they're going, which is a huge thing. We never know. We know what the case is about, but we're not sure whether we're getting all the data out. But I got to give you a funny anecdote. It was a case where a doctor had testified for me, and 3 of the questions from the jurors were, hey, Judge, could you give us the doctor's telephone number and address so we can contact them for our family and friends? And I turned to the lawyer and I said, that don't look good for you. So, yeah, it helps.
It helps. It's unique. It's unique to see. But we're talking about not only the jury, but also the witnesses that testified. And we saw the testimony yesterday, Bob. We saw it of a key nurse, a nurse that testified, Blair Brown. And she was brought forward she was recalled by the defense, and she said, I never heard Mr. McIver say that he shot his wife by cleaning it in a sink, which is something that another nurse said. There was at least one nurse who said, well, I overheard Mr. McIver said he was cleaning his gun in the sink and it went off, trying to show that he's changing his story about how the gun went off. I think the defense has been doing a great job so far of really hitting every single one of the prosecution's points. I'm curious, where do you think they're going to go with the rest of their witnesses moving forward?
Well, I think the defense from the opening statement, I think I was on with you, Jesse, when it happened, especially the woman, I forget her name, is amazing. I think she's really good. She's got a good rapport with the jury. She's got a good cadence. And I was watching on redirect, because that's a great art form, because a lot of lawyers don't know how to, Italian, they call it chiude la bocca, shut your mouth. When you stand well, stand still. So you only want to go on redirect if you have something really, really important to say. And what we just saw, for example, which he just did with this witness on redirect, was not just, wasn't flustered, obviously the prosecution didn't score any points.
Yeah.
But I love that part where she says on redirect examination, he was obligated to pay that loan back, and in fact, he did pay that loan back. So she's really good and strategic in how she goes about dismantling each and every aspect of what the state's case is. I think she's phenomenal.
Yeah, she is doing a great job. Let's play you some of Blair Brown's testimony. Again, the nurse who attended to Diane McIver when she was brought into the hospital. Take a look. That's Blair Brown, a defense witness, really countering that point that was made by the prosecution that one of the nurses they called said, I heard Tex McIver said he was cleaning a gun in the sink when the gun went off. Well, you heard Blair Brown, who was standing right next to them when they were brought in. She never heard anything like that. Okay, but what I want to play for you right now, as we talk about great witnesses, is that was a strong witness for the defense. But the prosecution had a pretty strong witness with Jeff Dickerson, the man that was hired by Tex McIver to be his crisis management consultant. Take a look. We have a short package about this testimony.
Former spokesperson and critical witness Jeff Dickerson took the stand in the murder trial of prominent Atlanta attorney Claude Tex McIver. McIver stands accused in the shooting death of his wife Diane. The prosecution believes the defendant had financial motives for the killing and went to great lengths to have the charges drop and hinder the investigation. Dickerson took the stand and testified that McIver hired him to manage and interact with journalists. Dickerson knew the district attorney of Fulton County, Paul Howard, and offered to reach out to him. McIver said he would offer a bonus if he could make that happen.
That it would be okay with him, I think were his words, if I shared that with others. And I asked for clarification because I thought that he might have some other communications team or others working on this project. And in seeking that clarification, it became clear to me that he was making reference to the district attorney.
Dickerson claims he attempted to contact Howard to eliminate or reduce the charges. But once he told Howard who his client was, Howard stopped responding.
How did you attempt to contact Mr. Howard?
By text message.
And can you tell the jury, what did you say to him?
I'd like to talk to you about a new client.
Did he respond to your text message?
Yes.
Okay. And what did you say back to him after he responded to your text message about wanting to talk to you about a new client?
I told him who my new client was.
And can you tell the jurors, did you receive a response from Mr. Howard once you said to him that your new client was Tex McIver?
I received no response at all.
Howard's silence was a clear indication that the request was inappropriate, but McIver apparently didn't care.
Can you tell the jury, did you communicate that to the defendant?
Yes.
What did you say to him?
He hasn't responded. He's not responding, and I think that that's instructive. I think that says a lot.
What was his response?
Disappointment. Try again.
On cross-examination, Dickerson admitted McIver never directly asked him to bribe Howard.
Mr. McIver never said to you, tell Paul Howard if the charges are dropped, there'll be money in it for him. Did it?
No.
For Law&Crime, I'm Rachel.
Okay, that's a big point that I want to stress about right there, whether he thought that this seemed like a bribe or was he actually told to give a bribe. We'll talk about that in a second because we are on break right now in the Claude Tex McIver case. They are on a morning break. As soon as the feed comes back, we'll make sure to go to it. But I want to talk again with Law&Crime trial analyst Bob Bianchi. That's an important distinction, no, in the sense that when he was under direct examination, Jeff Dickerson, he said that Tex McIver told him that if he could get the charges dropped because of his relationship with D.A. Howard, then there's a bonus in it for you and you can share it. And he thought that meant, he said it was very clear to me, that meant I could share it with the DA, and he knew that was illegal and unethical. But under cross-examination, he said Tex McIver never actually used the words, share it with D.A. Howard. How important is that?
It's, again, the prosecutor asking, first of all, it changes the theory of what the prosecutor said at the beginning of the case. The cross-examination exposed it's a little bit different than what was being told to you, but you're asking the jury to speculate as to the meaning of words. And Jesse's very important, because if you're a trial lawyer, you know at the end of the case, the judge reads the law to the jury. And when they get to a part, I'm pretty confident the defense is going to ask for the oral statement charge, which basically says when individuals are communicating with oral statements, you have to be highly suspicious of those communications, because different words, a change of a word, a nuance of the way it's received as opposed to the way it's said could substantially alter the meaning of the statement. So, ladies and gentlemen of the jury, be highly critical. You may look at independent evidence, other evidence, combination of evidence to see what you believe that statement was. That's not a good prosecution charge. I never liked it when I was a prosecutor because we would introduce oral statements of things people said, and I had to be worried about that jury charge because it's very, very powerful. And guess what? Not only is it right, is it true that we understand this is in human nature, on cross-examination it happened. What was alleged on direct examination changes now on cross-examination, proving the very point.
And you saw that a lot with the nurses, how they had conflicting testimony.
Yes,
right?
that's very, very compelling, and I'm sure the defense is going to make a big job of it. Not bad people. They're trying to do the best they can. Nobody thought that they were going to be here a couple of years later on a murder case, having to recount an innocuous statement that was being made. And so there's confusion. But, ladies and gentlemen, the burden is on the state to prove this case to each and every one of you beyond a reasonable doubt. And how can you not have a reasonable doubt with respect to that statement when you have two people saying different things about what that statement was? It's given the burdens that the state has to prove with solid evidence, with proof beyond a reasonable doubt, with the presumption of innocence to all 12 jurors. These things that are contradicting one another or within their own witnesses is a big problem. And I'll give you one last point. One of the best law enforcement officers I ever worked with, that was the best interviewer I have ever known. He could get anyone to talk in the right manner, in a constitutional way. In fact, he was once argued that he was too nice to targets of statements. Was very, very keen at understanding that people sometimes lie and make things up and spin things, not necessarily because they committed a crime, but for some other reason. Say, for example, an affair, or for this guy, he's worried about his reputation. Yeah. And things of that nature. And I'm sure the defense is going to hammer that home in summation.
It's going to be interesting to watch, Bob. They are on a morning break right now, so we're going to show you some more of Jeff Dickerson's testimony. Again, he was a key witness towards the conclusion of the prosecution's case. And even though Bob makes a great argument about how much to take from what he said, at least maybe one juror took a lot from it. So let's listen in to Jeff Dickerson's testimony. Okay, everybody, that's Stanley Smith, the estate lawyer testifying. He's been on for all this morning, and he was actually started his testimony yesterday, so he's been on for a while, trying to understand what happened after Diane died. Did Tex McIver do what he was supposed to be doing as the executor of the will? Again, I'm here with Bob Bianchi, and as we look at this, we could talk all about this. We talked about it this morning, but I have a bigger question for you. We know that Tex McIver was initially charged with involuntary manslaughter and reckless conduct. I thought it was a mistake to up that to murder charges because it seemed like a pretty open and shut case. How does it work to get a lesser included, in other words, during the jury instructions and say, hey, listen, jury, if you don't find my client, if you don't find the defendant guilty of murder, you could find him guilty of this lesser charge. How does that work?
Yes, a real nuanced tactical question. So first, I think the viewers want to know a lesser included offense means something that may not be murder, but may be less than murder. Now remember, murder, what they're trying to prove here is that he purposefully did this, all this motive evidence. He did this to kill her over money. So as a prosecutor, when you have to try to say this, you don't want to go, and by the way, if you don't find that it's murder, how about manslaughter? If you don't find it's manslaughter, how about involuntary manslaughter? And if you don't think that, you don't want to give a Chinese menu of options in your prosecution because you're essentially saying you don't believe your own case. The way you do it is that the way I would do it at least, is to say that, listen, folks, without any question, when he was initially charged with manslaughter, involuntary manslaughter, there's no doubt about that. Even if you want to accept what the defense is doing here, it was a completely reckless act under these circumstances. So those charges, when they were initially filed, were appropriate. But why did we upgrade those charges to murder? And why do we know we proved those charges beyond a reasonable doubt to you? Because of the financial motive, because he tried to bribe a witness. That's at least this is their theory of the case, what they're doing in summation. He went and he tried to spin this tale with his media agent. He did this, he did that, he did the other thing. In other words, you have to give the jury an idea of why it is that if they don't go to murder, they should go to involuntary manslaughter without saying, hey, in case we didn't prove our murder case, could you pretty please, can you do manslaughter for us? You don't want to do it that way.
Tough job for them. We'll have to see how it goes. Let's listen in live back in the courtroom.
I don't think I was aware of that.
Okay, everybody, it looks like the next witness will be called. Stanley Smith was on the stand for quite some time. This appears to be the next witness in the defense's case. It should be noted the defense will most likely rest their case by tomorrow, which means we may see a verdict next week in the Tex McIver case. I know it's been going on for such a long time, but there's so many moving components to it. I can't wait to see who this next witness is. So let's listen in live. For anybody just joining us, this is a live feed into the Claude Tex McIver case. A prominent attorney is on trial for shooting and killing his wife, but he is claiming it was all a tragic accident, that while he was in the backseat of a moving car, the gun went off by itself, or by accident, I should say, and his wife, unfortunately, was shot and killed. Now, you might be wondering, why is the CEO of a mining company on the stand right now? Well, we know that Tex McIver had an interest in a mining company. So I want to talk about this more with Bob Bianchi, our law and crime trial analyst. The idea that what the defense seems to be doing here is saying, okay, Tex McIver didn't need to kill Diane McIver for money. He had a strong interest in a mining company. What do you think about this strategy?
I think it's good. I have confidence in the defense. I'm going slow with my answer to you, Jesse, which you know isn't my style, because I'm still just nervous that they've done so well, the defense, that they could trip up. But they're really smart and sharp. I think it's a good part. It's to say, listen, you could say he didn't have the money or was cash poor, so he killed his wife, which I think is a difficult argument to make, again, without a background there. But he had his own financial interests, or whatever that could have been lucrative, so why would that motive apply? I guess that's the purpose of this testimony.
And let's not forget that Diane and Tex came together later in life. It's not like they grew up together and were high school sweethearts. They both came together with their own professions, their own career, their own income. So it's a little bit different. But Bob, I got to ask you the million-dollar question, speaking of money. Will Tex McIver take the stand?
Tex McIver should not take the witness stand. As my mentors had taught me when I was a young trial prosecutor, juries love to convict people based upon the words out of the mouth of the defendant on the stand. It is not a fair environment. Cross-examination, although these I don't believe are extremely skilled cross-examiners, could trip you up. And I used this expression yesterday. I'll use it again. A judge taught me this, brought me out in front of the courthouse and said, you see what that says up in the courthouse? Told me this is a young prosecutor, so I'm doing it by experience. It said, if you stand well, stand still. It was a great point that he was making to me, and I would make it to Tex McIver. You have done so good at putting holes in the state's case. It's their burden to prove it to 12 jurors. The only thing you could do by getting on that stand is mess that all up, my opinion.
So in other words, he doesn't have to go on and explain how the gun went off, why he fell asleep, what his idea was, what was going on in his mind. All of that's unnecessary.
No, because it's this. Obviously, the jury is told that the defendant has a right not to testify at trial. They're given a very strong jury instruction at the end of that. And the defense gets up there and says, there is no need to go any further. I mean, look at the mess that you have two nurses. One nurse says one thing, another nurse says another thing. You have a firearms expert who's trying to say that he purposely tried to shoot her, yet the gun accidentally went off. No, didn't go off, but he pulled the trigger while he's on the stand. You have this problem, that problem, the other problem. Tex McIver can only tie. Prosecutors die for that. When I was dying, please, defendant, take the stand. Please take the stand. Let me have a crack at you at cross-examination. And I've won some cases on cross-examination of defendants that I was on really, really shaky ground until the defendant took the stand, and that was the case closer.
All right, ladies and gentlemen, let's listen into Ted Smith. He's the CEO of Arkilla Mining. Let's listen in live. All right, everybody, so you're watching Ted Smith, the CEO of Arkilla Mining, testifying about Tex McIver's interest in that mining company and owning 2 tracts of land, basically that he had money and that he had a value in a pretty expensive piece of property. In other words, he didn't need to kill his wife, Diane McIver, because he had money. He had money. So I'm going to ask, because he's such a great attorney, I'm going to ask Bob Bianchi, who's our law and crime trial analyst for this morning. Bob, explain to me the counter argument here, okay? What is the strongest argument that Tex McIver had a financial incentive to kill Diane? Because we talk so much about the prosecution's lack of a case, but there has to be something here. So tie it for our viewers. What is the strongest way to make an argument for that he had a financial motive to kill her?
You're really asking me to stretch my brain here based on what we've heard and the evidence in this case, but I guess the argument I would make as a prosecutor is that, hey, folks, you don't understand what Tex McIver represents. Here's what he represents. an outward appearance to people, looking like a big shot, looking like he's got the cash to spread around, looking like he's well-heeled. But we know differently, don't we? We know that he was failing in his law practice. He was leaving his law practice. We know he had debt. We know that he was cash poor. And guess who had the money that he needed in order to continue with that appearance? His wife. And how do we know that this isn't an accident as opposed to a murder? Well, look at the manner in which it occurred. It's something to that effect, Jesse. But I would have to say it's because of his ego, his arrogance, his need to cast images, and, of course, a will that was taking some of that booty, if you will, that dollar booty, and giving it to other places, and he was not happy about that.
That's a great argument, Bob, and I wonder if the other way to say it, and you talk about an ego, I haven't seen so much of that Tex McIver ego from witnesses. It seems that he was a normal guy. People liked him, knew that he loved his wife. I don't see that yet. But here's my question to you. Couldn't you say, well, again, and I mentioned this before, they both came together later on in life, right? So they weren't high school sweethearts. They didn't build their careers together. They both had separate careers and separate lives. Now, if I were to say to you that Diane McIver was the breadwinner and she was paying for their whole lifestyle, trips, restaurants, vacation, then why would she need to loan him money? That's the counter argument here. So what would you say to the people that say, well, wait a second, she was the breadwinner, she was supplying their whole life, he had no reason to kill her. What's the argument to say, well, he did want to kill her because they had a more formal relationship than I'm understanding? What's the other argument there? Okay, well, the argument that I would be making as the prosecutor is he could not take the fact that she was the breadwinner, and she had that around him like a noose around his neck. She was making fun of him, oftentimes saying to him, you can't have this, can't have that, like a mommy would be taking care of a child. And a guy like Tex McIver cannot continue to deal with that. He wasn't good enough that she was just feeding him the money and humiliating him in the process. He had to take her out so it could all become his. And I think you make a really good point, Bob, because we keep seeing about Diane McIver's attitude, for lack of a better word, right. And I don't want to be disrespectful, but that is really what the prosecution has painted, that she might have been a difficult person to get along with. She had a sharp tongue, and you see from these different email exchanges her teasing McIver, Tex, about his financial situation and teasing him about that. I think there's something to that. Strangely, that seems to be maybe the strongest part of the prosecution's case. What do you think about that? No, yeah, like I said, I think that the idea that she's in control of the money, she's kind of humiliating and him and keeping that noose or chain around him all the time, the fact that she's looking to maybe dissipate some of those assets becomes a toxic cocktail with which he can't take it anymore, and it's more out of the ego and his anger at the fact that she continues to, you need a loan, why do you need this loan, you're not good with your money, you don't know what you're doing, that he finally snapped. It's a good argument. We'll have to see if it works. Let's go back live into the courtroom right now. Okay, so you're learning a little bit more about Tex McIver's financial interests, but before we do that and dive right back into it, and again, you're watching the testimony of Ted Smith, the CEO of Arkilla Mining, I want to, unfortunately, I should say, I have to sign off my guest for this morning, Bob Bianchi. Bob, what are your final thoughts of this case as we enter into all of the conclusion of the case, maybe starting tomorrow? It's like Mr. T said, it's like pain and fatigue. I've never seen a case with so many witnesses in my life, which is always bad for the prosecution. I think the defense is doing a great job. I think they should just get out of this case as quickly as possible and get the summations. And Jesse, listen, it's always a pleasure being on with you, discussing these cases, and to all those folks online who've been very kind and your kind comments and some very, very insightful things. I look at them and suggest to Jesse that we pitch some of those ideas. Thank you very much, too. Well, Bob, we always love having you on. Thanks for joining us, and we'll see you soon. Maybe we'll come back to talk about the closing arguments or maybe some other witnesses here in the Tex McIver case. Thank you. All right, everybody, let's go back live into the courtroom.